So, just a moment.
Recording in progress.
And I apologize for the little bell that goes off every time someone enters the room, but I thank you for all being on mute. I'll be calling on you in just a few moments. This is the City of Jackson against the City Council of Jackson, the 1st Judicial District, cause number 22-00281. On March the 9th, Mayor Lumumba, on behalf of the City of Jackson, filed an emergency complaint for a declaratory judgment against the Jackson City Council. The complaint was filed by Felicia Perkins. Is Ms. Perkins present?
Good afternoon. I am here.
All right. Thank you, Ms. Perkins. City Council filed its answer on March 14th, filed by Attorney Deshaun Martin. Mr. Martin present?
Hey, Justice, how you doing?
I'm good.
I'm here.
Welcome. And
Thank
then
you.
on March 15th, Waste Management of Mississippi, Inc. filed a motion to intervene. The motion was filed by Mr. Chase Brown. Mr. Brown, are you present?
Yes, sir. I'm here.
Good. All right. And on March the 15th, also Waste Disposal Services, LLC, filed its motion to intervene. That motion was filed by Attorney Robert Gibbs. Mr. Gibbs, I can see you're present. Let me make sure I can hear you.
Yes, sir, I'm here.
All right. Also on March 15, Waste Disposal Services joined Waste Management's motion to intervene, and that joint motion was filed by Attorney Jamie Travis. Mr. Travis, present?
Yes, Your Honor, I'm here. Our argument will be made by Robert Gibbs.
All right. On March the 16th, Mr. Bryant, on behalf of Waste Management, filed a transcript of the March 8th City Council hearing, which I have reviewed. I noted that also on March the 18th, a notice of appearance was filed by Attorney Katoria Parker on behalf of the City of Jackson. Is Ms. Parker present?
Yes, Your Honor.
All right. And then finally on Saturday, March the 19th, Richards Disposal, Inc. filed a motion to intervene. That motion was filed by Attorney John Walker. Is Mr. Walker present? If you are, Mr. Walker, you need to unmute yourself.
John Walker's present. Along with Attorney Gloria Green.
I beg your pardon?
I said, yes, John Walker's present, Your Honor, and I was saying also with me is Attorney Gloria Green.
All right. And I believe Richards Disposal also filed a memorandum in support of their motion to intervene, which I've reviewed. So it looks like I have Ms. Perkins and Ms. Martin on behalf of the City of Jackson and Mr. Martin on behalf of the City Council. Any kin? Ms. Martin, Mr. Martin. Pardon?
No, Your Honor. And actually, the City of Jackson entered an appearance just as an interested party. We're not appearing here on behalf of the City of Jackson because there's been no complaint filed against the City of Jackson. I think Ms. Felicia Perkins is representing the mayor, Chokwe Lumumba.
But Judge,
just a moment. Just a moment, everybody. We got too many people here for people just to cut in and talk. So just give me a moment, okay? It appears to me that the complaint in this case was filed by the mayor in his official capacity as mayor of the City of Jackson. I'm having trouble understanding the distinction between the mayor and his official capacity, in his official capacity as the mayor of Jackson and the city of Jackson. So, counsel for the city of Jackson who disagrees with that concept, I'll hear from you on that.
Your Honor, this is Katoria Martin on behalf of the city of Jackson. The mayor filed the lawsuit in his official capacity. However, the office of the city attorney is representing the interests of the city itself, not the mayor and not the city council in this matter.
I don't understand the difference in the mayor in his official capacity as the mayor of Jackson and the city of Jackson itself. Are you saying they have diverse interests?
Yes, I'm saying that there's a conflict of interest between the city mayor and between the city council, and so the office of the city attorney is conflicted out of this matter. We're interested in that we're representing the best interest of the city, but we are not representing the mayor in this matter, and we are not representing the city council in this matter. There's been a conflict of interest, and so they each have their own separate counsel.
Well, I've read the complaint, and it appears to me that the mayor didn't enter into a contract on his personal behalf. He entered into a contract on behalf of the city of Jackson. Now, if you're taking the position he didn't have authority to do that, I haven't seen that.
You are correct, Your Honor. We are in agreement that he entered into a contract on behalf of the city of Jackson, and it was on our advice. The office of the city attorney.
Are you taking the position as Mayor Lumumba's contract or the city of Jackson's contract?
It's the city of Jackson's contract. That's the reason why we're here, Your Honor. It's the city of Jackson's contract, but we did not file this lawsuit. The mayor filed this lawsuit. That's all we're trying to clarify.
So you're taking the position the mayor had no authority to file a lawsuit?
No, that is also not our position. We are not taking the position that the mayor did not have the authority to file the lawsuit. So our interest, I believe someone else is speaking.
Everybody needs to be on mute except the person who's speaking. Go ahead. Who is this? Is this Ms. Perkins?
No, this is Tori Martin. This is Katoria Martin on behalf of the city of Jackson.
Ms. Martin, do you know how to change your name on Zoom? Do you know how to?
I do. Did you like for me to do that for you?
I'd appreciate it. Anybody else who intends to speak today? Well, we can take this up later. As it stands right now, just for your information, I don't see the difference.
Okay.
If the city, either the mayor had the authority to enter a contract on behalf of the city or he didn't, and it would seem to me that you would need to file some kind of pleading if you're taking the position that he didn't. But I'll save that for another day because I'm not here about anything except motions to intervene. So,
understood, Your Honor.
All right. So let me say this to begin with. In this hearing, as in all of these hearings that I conduct, either by special appointment of the Supreme Court as to a particular case, as in this case, or as a special judge or chancellor for, or county court judge for Hinds County, I believe that all of these hearings are open to the public. And so, to the extent any of you file a motion and we are going to have a hearing by Zoom, which I prefer, then you need to provide, or I intend to provide, a link to the hearing to the Public Information Officer for the Supreme Court, Ms. Kraft, and she's going to make that available to anyone who wishes to attend and view the hearing. I think it's open to the public, and I think that's an important concept. So, but it is important that those of you who are here to view the hearing keep yourselves on mute and don't disturb the proceedings. I also, before we begin the argument, want to say that I have read the briefs that have been filed and the motions that have been filed, and the test for intervention, either a mandatory intervention or an intervention as of right, depends partially on what the intervenor claims their interest is, and they would be entitled to receive, or what benefit they'd be entitled to receive were they to prevail. And to that extent, I think it's necessary that I hear from you a little bit about the merits of the case. This is not going to be a hearing on the merits of the case, but to the extent you need to discuss the merits and not just the law associated with intervention, I'll allow you to do that as it relates to how it might affect the intervenors, the three intervenors' rights to intervention. So with that, other than the arguments on intervention, does anyone have anything else before we start?
Just
All
as
right.
you asked,
I'm sorry, Mr. Martin, go ahead.
just as you asked, was I related to Miss Martin? Not biologically, but yes, I know her and I respect her eminently. That's what I wanted to say.
That's fine. I respect all of you. I just didn't want there to be a conflict that later caused us to have a problem with this hearing. So
No, sir. No, there are no blood ties. No, sir.
okay. All right. Let me hear from Waste Management on your petition to intervene.
May it please the court, Chase Bryan for Waste Management. I know you know the law on this, so I'm not going to belabor the law. I'm going to focus on one principle, though, and it's this idea that when you look at intervention, you look at it through the prism that the benefit of the doubt goes to the party seeking to intervene. And so here, you look back at the Hayes versus LaFleur County case, which we cited. The court stated there's much to be said for an overall attitude which gives the benefit of the doubt to the one seeking intervention, particularly where intervention of right is claimed under Rule 24A2. And so, as you know from your time on the Supreme Court, that intervention analysis is a fact-intensive inquiry for the court, and the benefit of the doubt will go to those of us moving to intervene. I'm frankly surprised that the mayor objects to us intervening. I certainly think Richards has a right to intervene, and Waste Disposal Services does as well.
Let me stop you. Let me stop you right there, because I want to. You've hit on a point that that I'm going to talk about after everyone has made their argument. But you mentioned that intervention is fact intensive. Is this really a fact intensive issue before the court, or is this just a disagreement and argument over the law and how it applies to the facts that are agreed? I mean, what facts are in disagreement? I mean, nobody disagrees there was a city council meeting and the transcript says what it says and the mayor's proclamation says what it says. The documents are what they are. And I've been unable to discern any factual disagreement. And to that extent, I'll go ahead and, excuse me just one moment, but to that extent, I'll go ahead and give you a foreshadow of what I'm going to be asking you later. I'm trying to determine whether or not this case needs to be tried in a courtroom with a court reporter, or whether or not everyone can just agree on the exhibits and submit memorandum of law, and I decided on the memorandum. But I'm not asking you to answer that now. I will be later in this hearing, but for now, tell me what facts are in disagreement.
Well, I think when I said fact intensive, I misspoke. I think what the thought I intended to convey was that the right to intervene turns upon the facts of the case. I think that we probably all would agree that the relevant facts are largely undisputed in the case, and so you're right about that. So I may have misspoken. That was not my intention. I think it just varies depending on the facts of the case, is what I intended to say.
Understand? Okay. So I'm sorry to interrupt you.
That was what I was trying to articulate, and the merits of this do relate to why we should be able to intervene, and frankly, why Richards should be able to as well. What we basically have here is we have a situation where the applicable statutes and law don't answer the question before the court, because what's supposed to happen is the mayor is supposed to recommend a contract and the council approves it. But here we've had a history of the mayor recommending contracts and the council not approving those. And so when the mayor has not gotten his way with the vendor he selected, he has created these manufactured emergency proclamations. If you go back to the fall and that timeline we put together, this is Yogi Berra would say deja vu all over again. We've seen this movie before. We did it 6 months ago, and the exact same thing happened. Rather than follow the RFP process through its logical conclusion, when the mayor didn't get the vendor he wanted approved by the council, he filed an emergency proclamation, a lawsuit was filed, and literally in the Chancery Courthouse, we reached an agreement to extend the prior contract for 6 months. RFP goes back out in the fall, and we look up in January, and now he's picked Richards. The council didn't approve Richards once and twice in January. So same problem, and that was around February 1st when the second failure to approve. 8 weeks before the end of the contract, on February 17th, there's an emergency proclamation by the mayor saying, I get to pick the vendor because there's an emergency. And the next day, we sent a letter saying, we'll extend the contract for 30 more days. So from the day of that letter to the offered 30-day extension was 10 more weeks to work on this. So there was not an emergency at that point in time that required a contract to be awarded to circumvent the RFP process. And then we're going to get to the issue in a second about why are we entitled to intervene. And this case is not in our initial brief. I'll send a copy around after the hearing for your honor, but the Madison HMA versus St. Dominic case is just about on all fours here. In that case, there were two different contracts and there was a dispute. And so one of the other parties claiming a contract was allowed to intervene on appeal. So that's what we have here. We have the mayor declaring an emergency proclamation and issuing a contract to Richards. You have the city council on February 24th amending the emergency proclamation and selecting Waste Management to have the contract. So you have these competing awards for the contract. And the question that you'll ask and the mayor's attorney raised was, what interest do we have that allows us to intervene? Well, we actually were, in our view, awarded a contract by the city council. And the mayor will argue, well, only I get to pick the vendor. That's typically true, but not in this case. And there are no reported cases in Mississippi that we can find that are on point with this topic. There is one AG opinion that is the closest thing that we found. It's the 2007 Charles Lawrence AG opinion from Hattiesburg. And in that matter, the mayor there raised the exact same argument the mayor raises here, which is only I can execute a contract. And the AG, looking at that issue, said when the mayor refuses to act, and here he refused to act by following the RFP process down through the list of qualified bidders, he doesn't have the right to select a vendor when he doesn't do his job. And that's what's happened here. He's not done his job, and so the city council has tried to step in and take care of this problem with the trash contract. So that's sort of the nutshell of our argument. And our interest is in a contract award from the city council, which is more than an economic interest. It's a contractual right in our mind that just has to be formalized. And I think that we should be entitled to come into the case. Richard should come in and defend their interest. They're in the same boat we're in, where the city has not followed the typical process to award a contract. And so, simple as that, we're entitled to intervene and protect our rights in this matter.
So in a nutshell, your argument is that if the mayor wins, you don't get the contract. If he loses, you do.
I think that's about right.
All right.
I think what you have to decide is the issue is what happens when there is this impasse where they both think they're right. The statutes don't address this. I mean, the closest thing that addresses this is the AG opinion.
That's more to the merits, and I get that. I get that as the issue to be decided. But in trying to zero in on what your client's interest is, it is that the determination of this litigation decides whether or not your client gets a contract.
I think that's right.
Okay. All right.
And the inverse is true for...
Yeah, and with respect to And with respect to city council, rather than have you respond to each of these prospective intervenors, I'm going to have the city council attorney respond after everyone's made their argument, and I'll give you plenty of time to respond to all of them. I realize that it's a little bit unfair either way I do it, but I'm going to reserve the city council's argument to the end. So waste disposal, let me hear from you.
Judge Dickinson, this is Robert Gibbs. I don't have much to add. My argument is pretty similar to waste management. But just so you know, waste disposal is a minority company that has to subcontract with waste management to pick up trash in Jackson. So when your analysis is that if the mayor loses, waste management wins, the same would apply for waste disposal, because if waste management wins, we will continue to operate. We have a small company, 40 employees that are on the verge of trying to decide whether or not they will have a job after the end of this month. So while we certainly have a financial interest in this case, we also have a contractual issue as well. Thank you.
Okay. And Richard's disposal, let me hear from you. Counsel for Richard's disposal.
Ms. Attorney Green will be addressing for Richard's disposal.
Very well.
Good afternoon.
Attorney Green, have you entered an appearance in this case?
I have.
Okay. I just want to be sure
I'm
if you have.
I'm one of three of us who is listed.
Pardon me?
I say I'm one of three listed in the pleadings.
Very well. Go ahead.
Okay. Good afternoon. As was said, my name is Gloria Green, and I am an attorney with the Walker Group. The Walker Group PC represents Richard's disposal in this matter. Now, 3 days after the City Council filed its motion for emergency hearing and injunctive relief, Richard's disposal moved to intervene to protect its interest in this case. Prior to that time, Richard's disposal did not feel that it had any interest to protect. So Richard's disposal's proposals are that it should be allowed to intervene as a matter of right under Mississippi Rule of Civil Procedures 24. And first, we would say, as previously stated, that Richards did file his motion to intervene timely because it was done within at least 3 days after the motion for emergency hearing filed by the City Council, which triggered Richard's interest. Secondly, Richard would say that it has an interest in the subject matter of the proceedings for two reasons mainly. The first one being under the RFP, Richards was chosen as the most advantageous proposal under the RFP. And Richard submits that its rights being accrued under 31.713R of the Mississippi Code. That is the code that specifically talks about the procurement of solid waste services. And according to that code section, once Richards is selected, the contract shall be awarded to Richards. Not maybe, but it shall be awarded to Richards. So that is Richards' interest in here. It goes further than a financial interest. It actually goes to the fact of whether Richards' statutory rights would be honored by the City Council. Then the next thing is that Section 2.3 of the RFP. That is the provision that talks about when the city would move from one proposal to the other. And under that section, it specifically says that the only way the city would go to another proposal is if the first proposal does not agree to any terms submitted by the city. Richard submits that it has agreed with all terms and conditions proposed by the city. And as a matter of fact, the city and Richards actually successfully negotiated the contract. And this was the contract that was presented on January 4, 2022. And then Richard also says that it has an interest in this matter pursuant to the emergency agreement. Now, the mayor declared the emergency under Section 3315.17. And in 3315.17, it states that the City Council ratifies the continuing need for the emergency, not the contract. And so Richards contends that its emergency agreement is fully executed agreement that should be honored by the city. And with respect to the questions about the city council disapproving Richard's contract.
Let me stop you. Let me stop you just so I don't get ahead. You don't get ahead of my thinking. I heard what you just said about the statute saying that the council takes action on the mayor's declaration of an emergency. Are you saying that the mayor can enter into a contract for these services without approval of the council?
That is what the statute says. The statute only says that that the council determines the need for a continuing contract, emergency, a continuing emergency. And what we would do is submit for your honor perusal is the case of Bolivar County versus Walmart Stores, Inc. And in that case, the court specifically says that when you're dealing with section 3315-17, the emergency management law, that the traditional procedures regarding purchasing and obligations and contracts do not apply. So that's Richard's position with respect to that. And that is also the position that was articulated to Richards when we were in negotiation with the city attorney's office, that contract would be one that could be entered into during the pendency of the declared emergency.
So your interest, Richard's interest in this litigation is if the mayor prevails, your client gets the contract, and if not, your client doesn't get the contract.
Right. Our interest is twofold. The first one is with the RFP contract. Richards is saying that by the action of the council has denied Richard a statutory right that it has to the contract. Now, much has been said about the right of the council to approve or disapprove a contract. We don't disagree with that. But our position is that the council's right to do so is not unfettered, that it cannot just arbitrarily go out and reject a contract. At no point in time has the council articulated any reason why Richard should be denied the contract. As a matter of fact, what Richard submitted is that the council has not followed the procurement law of Mississippi, and in that result has denied Richard his contract.
Did you locate any case law that addresses the question of whether the mayor does not need to get approval of the council in circumstances where the council acts in an arbitrary or capricious fashion, which seems to me to be what you're arguing here? Do you have any cases that say that?
The case that I have is simply that the council should not do that without cause.
No, I'm saying, do you have any cases where that issue's been before the Supreme Court and been decided?
I wish I did.
Okay.
But I don't have one. I have not found a case which says that the mayor could go on and enter into a contract that required the city council's approval.
All right.
Without more, which I understand is the reason for this case.
Well, it's an interesting issue, and I've not been able to find any law on that either. So, anything further?
Yes, and Your Honor, the other thing that Richards would like to raise is the fact that we are not aware of any minutes that have been issued with respect to Richards' RFP or Richards' contractual rights with the city by the city council. So, according to my understanding of the law and according to the statute, until those minutes and the case law, until those minutes have been issued, the council really has not taken any official actions.
All right.
And the statute that I would refer to is section, as well. I would refer to the section is section 21-1533 of the Mississippi Code, and I would also refer to certain technical advice that has been given out by the Mississippi Auditor's Office.
Okay. All right. So let me hear. I don't know whether I need to hear from the city of Jackson or Mayor Lumumba or both. I'm caught off guard here as to the difference in interests of the mayor and the city when the mayor is in his official capacity. I actually thought the mayor hired the city attorney. But I'll tell you what, let me hear from the city of Jackson and hear whatever this issue is that you are saying causes the city of Jackson not to be involved, not to be in this case at this time. Let me hear from you on that.
Your Honor, this is Katoria Martin again on behalf of the city of Jackson. And I do believe that we're walking a fine line as the office of the city attorney in this matter, because we are charged with representing the municipality as a whole. So throughout this process, we provided advice to both the mayor and the city council up to the point at which the mayor filed suit against the city council. We represented the city of Jackson and its interests. At the point at which the mayor filed suit against the city council, a conflict arose, and the mayor had his own counsel, and we advised the city council that they would need their own attorneys to represent them. We reached out to the Mississippi Bar with regard to this case to make sure that we understood what our role should be in this matter. And what they asked us was whether there was a complaint that was against the city of Jackson. And our response was, no, there's no complaint against the city itself. It is the mayor and the city council. And our initial reading of the complaint and the answer was that it was an issue regarding the separation of powers between the mayor and the city council. Now, you asked earlier a question about the contracts themselves. Yes, this office did represent the mayor and the city council in negotiating and recommending contracts. And also throughout the RFP process, we represented both the mayor and the city council. And so the reason why I said we're walking a fine line in terms of this conflict is we provided advice to both. We are essentially, in the email I sent you previously, I said we're an interested neutral party. We don't have an opinion as to whether waste management.
Who is a disinterested neutral party?
The city.
All right, well, let me just tell you right now what my thinking is, and you may just need to get the Supreme Court to decide this issue, but my thinking right now is when the mayor filed a complaint on behalf of the city, the city is involved in the lawsuit. Now, if you think the mayor didn't have the authority to do that, you certainly have the right to challenge that, but what I don't think you have the right to do is come in and say the city's not in the case. My belief is the mayor has, under certain circumstances, the mayor has authority to file a lawsuit on behalf of the city of Jackson, and that's what I think he did. You may disagree with me on that, and you certainly have the right to do that, and I promise you after 14 and a half years on the Supreme Court, my opinions did not always prevail. But that's what I think. And if the city attorney's office or anybody else, any other entity, wishes to challenge the mayor's authority to file a lawsuit on behalf of the city, they can certainly challenge that authority. And the party or the entity making that challenge can't be the city. The city's in this lawsuit. At the city council's office, or you as city attorney or some other entity wants to make that challenge, you're welcome to do so. But right now, this case is going to be litigated with a contract entered into by the city of Jackson and some entity, presumably one of the other parties in this case. And Mayor Lumumba cannot enter into a contract on his own behalf. He has to enter into a contract on behalf of the city, and that's what he purported to do. And so I'm telling you, that's what my thinking is right now. If you think I'm wrong about that, and you have some authority, you have a case somewhere that has determined that the mayor who files in his official capacity as the mayor of a city is not filing on the behalf of the city, I'll be happy to look at that authority. But until then, that's what my thinking is, and I'm giving you the benefit of that just so you know where I am. I'm not telling you I'm intractable and that I couldn't change my mind. I've been wrong plenty of times. But I think you need to know that because that's where I am with respect to considering these motions for intervention. And
Your Honor, at this time, we do not wish to challenge the mayor's authority to bring this lawsuit on behalf of the city of Jackson. We entered an appearance simply because we are the party that negotiated these contracts that are being disputed.
all right, let me ask you this. If you were to win, if you were to hit it over the fence, tell me what it is you think I should do. What's your position?
Solid waste will be picked up in the city of Jackson on April 1st.
No, don't give me that. I'm asking you from a legal standpoint with respect to the structure of this lawsuit and the claims that are filed, tell me what it is you think I should do. With respect to the motions to intervene and the proceeding of the litigation, what is your position? Why are you here? Making an argument. I don't get it. Mayor Lumumba is here in his official capacity with an attorney arguing that the contract that he signed should prevail. Do you disagree with that?
No.
All right. So I'm not quite sure. I'm not quite sure what your issue is. I'm just confused, and I'm sure it's my fault, but I just don't quite understand if you're not disagreeing with the mayor in terms of his right to file the litigation on behalf of the city. I don't quite get what your issue is.
We don't have an issue. We don't disagree with his right to file the lawsuit on behalf of the city of Jackson.
Okay. Well, the mayor's here with different counsel. Do you disagree with the mayor's authority to hire other counsel to represent him in this issue?
We do not.
Okay. All right. Let me hear from counsel for the city council. I'm sorry. Anything further? I didn't mean to cut you off. Did you have anything further?
No, Your Honor. Not unless you have a question for us.
No, I don't. I'm just trying. I'm desperately trying to make sure I know what issues are to be decided before we lose everybody. And I understand. And thank you for that. Counsel for the city council. Let me hear from you. You may be on mute because I can't hear you yet.
Justice, forgive me. I said, may it please the court. Good afternoon, Justice.
Good afternoon.
And other counsel. On behalf of the city council, the citizens of Jackson, we have no issues, Your Honor, as the city council, allowing these interested parties to join in this litigation. We think it's proper under Rule 24.
So, city council does not object to the intervention. All right, let me hear from counsel for the mayor in his official capacity.
Good afternoon, Your Honor. This is Jessica Ayers with the Law Office of Felicia Perkins. My name is also on the filing for the emergency complaint. Your Honor, the issue before the court and the reason we are before this court is because of a conflict between the governing authorities of the city of Jackson, which is both the mayor and the city council. We have filed the emergency complaint on behalf of the mayor solely for determination of the rights and or legal authority of the governing authorities in a mayor-council form of government, specifically between the city council of Jackson and the mayor of Jackson, with regard to the declaration of a local emergency concerning the collection of residential solid waste. So, Your Honor, it's not a request for the court to determine whether a contract was valid. It's solely for the purpose of the court determining what role each part of the governing authorities of the city of Jackson has with regard to declaring a local emergency concerning the collection of residential solid waste. In their motions to intervene in the attached complaint, both Waste Management of Mississippi and Richards Disposal clearly indicate that their desire to join this litigation is purely based on their potential economic interests, which is also shared by Waste Disposal Services as they join into Waste Management's petition. According to Perry City v. Ferguson, to intervene, one must assert a direct, substantial, legally protectable interest in the proceedings, and economic interest alone is insufficient. If a movement's request to intervene in litigation is based on their economic interest alone, his or her claim for intervention fails on that lone factor, and that's in Cohen v. Cohen, 748 Southern 2nd 91, Mississippi Supreme Court 1998. The private companies which have filed motions to intervene in this action have neither an unconditional nor conditional right pursuant to Rule 24 of the Mississippi Rules of Civil Procedure to enter into this, because neither were conferred unconditional or conditional right pursuant to a statute. Further, because their requests are based on solely and purely economic reasons, they fail to satisfy the requirements of Rule 24 for intervention based on right. It mainly concerns the Waste Management and therefore Waste Disposal Services underlying complaint, mainly concerns the mayor's authority to declare an emergency and the mayor's obligation to participate in the process for obtaining solid waste contracts in accordance with Mississippi Code annotated 31713. Well, our emergency complaint has nothing to do with the request for proposal requirements under 31713. Our emergency complaint has to deal with what will occur and what legal authority the city council and the mayor have with regard to declaring a local emergency. That's what our petition. So therefore, the request of Waste Management of Jackson and by joinder Waste Disposal Services, they do not have the same questions of law and fact in common with the request for relief in the underlying complaint. Further, if Waste Management of Jackson and Waste Disposal Service argue that they should be permitted to intervene because they want to declare that the city council had authority to tell or direct the mayor to enter into a contract with them, then their interests will be adequately represented through the city council's request for injunctive relief and the mayor's request for determination of the legal authority of both the city council and the mayor with regard to declaring a local emergency regarding residential solid waste collection. Therefore, they should not be able to intervene in this action. And similarly, with Richards Disposal, their complaint indicate a desire to join this litigation based upon a conditional emergency contract signed by the mayor for the company to collect residential solid waste. However, their requests do not share the same questions of fact and law in common with the request for relief in this action. We are solely requesting the court to make a determination as to what legal authority and rights the city council and the mayor has in a mayor-council form of government. Furthermore, if Richards Disposal argues that it should be permitted to intervene in this action because it wants to declare the court to declare that the mayors had authority to enter into that emergency contract for the collection of residential solid waste, then its interest would be adequately represented through the mayor's request for determination of its legal authority. So therefore, Richards Disposal should not be permitted to intervene. So both with request under intervention by right and permissive intervention, neither companies should be allowed to intervene in this action. Additionally, if the court were to allow them to intervene in this action, it would place an unnecessary burden that outweighs their interests on the mayor and the city council, as they would both be required to defend against the city of Jackson against those respective claims. The reason that this is a huge issue and that both the city council and the mayor have conflict counsel is because they are their beliefs and their interpretation of the law do not agree, Your Honor. The city council, as you've seen, would be willing to allow the movements to intervene in this action, and the city does not. The city council does not believe that the mayor has authority to do certain actions, and the mayor does. So that's where there is a conflict, and why the office of the city attorney is unable to represent the mayor or the council in these arguments, because it represents the city as a whole together and not the separate parts of the governing authority. So that's why we have been retained, Your Honor, and we believe that neither resource disposal, waste management, or waste disposal should be allowed to interfere in this action. And Your Honor, we also agree that this action is not extremely facts intensive, in that it would probably be best served to go off on memorandums of law, because it is law intensive and not fact intensive, Your Honor.
So, I get your argument for the moment about Richards. If Richards agrees with your statement that their interest and the mayor's city's interest, as the mayor has filed this claim, are exactly the same. But what about the other two intervenors? How will their interest be protected? Because I hear what you're saying. I hear your argument that you're not really trying to litigate the contract and who gets it. You're trying to litigate whether the mayor had authority to enter into the contract. But the reality is that if you prevail, then one party gets the contract, and if you don't, another party does. So indirectly, this litigation will determine who gets the contract. That's point one. Point two, I understand the case law that relates to intervention as it is affected by an economic interest, but every case where a party seeks intervention affects an economic interest. It's where it's solely an economic interest. And here, the interest is acquiring the contract, which indirectly will inure to their financial benefit, but their claim is as to the right to enter into a contract or to have a contract. So I'm not sure that case law that you cite, I looked at it, and I'm not sure that it's right on point. But let me pause, Ms. Ayers, in your presentation just a minute and go to counsel for Richards and ask you what your view is of Ms. Ayers' suggestion that the mayor's interests, as they will be argued in this case, and Richards' interests are exactly the same. Are they not?
Judge, thank you. They are not the same. We differ in two respects. First of all, it is not solely an economic interest. Again, Richards claimed that Section 31.713 R gives it a legally protected right to this contract. So that's more than an economic interest. Secondly, Richards' position is that the emergency contract is not a conditional contract as asserted by Ms. Ayers, but it is a contract that was entered and fully executed. And in addition to the contract, the mayor also issued a notice to proceed. So it's more than just a conditional.
So your position is that if the mayor prevails, you have a contract. Unconditional, you have it. It is in effect.
Right.
And you say that Ms. Ayers doesn't agree with that. Is that your position?
Right. Ms. Ayers doesn't agree with it.
All right.
We don't think the contract is conditional.
All right, Ms. Ayers, let me get you to respond to that, because this is an important point.
The issue is, I'm not sure I understand, because the issue before the court is whether, and I understand, Your Honor, I understand you're saying that underneath all of this is the contract, but what we're seeking is the court to let us know what legal authority, because if the court does allow us, if the court agrees with how we believe the mayor has authority, the mayor's authority, then it is a valid contract with Richard's disposal. We do agree that it would be a valid contract.
Yeah, Ms. Ayers, here's what strikes me. You're arguing that what this litigation is about is whether the mayor has authority to enter a contract, and I really don't think that's true. I think what this is about is whether the mayor had authority to do what he did. That's what the complaint says. And the mayor, I mean, unless you're taking the position that the contract that the mayor signed is not a valid contract, if the mayor had authority to enter it, then I don't know. I don't guess I quite understand your argument. Help me out here.
Yes, Your Honor. Our emergency complaint specifically is for the court to declare that the city council has no authority to negotiate and or execute a contract for the collection of residential solid waste, absent the existence of the exception in Mississippi Code annotated 21-819, that the city council has no authority to amend the mayor's order declaring a local emergency, and instead, after the mayor declares a local emergency, the city council is required to approve or disapprove the proclamation, and that the mayor has the authority to find independent contractors or vendors who can provide necessary emergency services and present contracts to the city council for approval. That's what we're requesting. We're not asking the court to approve contracts that the mayor has previously signed. We're asking the court to clarify the roles that the city council and the mayor have under this the emergency statute with regard to declaring a local emergency. The movements, the interveners, potential interveners are bringing in this extra caveats to this case when we just want the court to declare, based on Rule 57, the law regarding the roles and the legal authority of the city council and the mayor. That's specifically what we're asking, not all of this additional stuff.
Well, I hear you, but you're going to have to state on the record for me to buy your argument. You're going to have to state on the record that if the mayor prevails in your request, he's taken the position that the contract he signed is not a valid contract.
No, he's not taking that position, Your Honor. He's taking the position that the contract he signed is a valid contract.
All right, well then if that's true, then what you're really asking for in this litigation is for the court to find that that contract is valid, because you are the result of this court's determination of that issue will decide whether or not that contract is a valid contract or it's not. That's what happens when this litigation, let's just say we go through the steps and I issue an opinion and I say, I believe the mayor prevails. If I say that and the mayor's claim is correct, if I say that, Richards has a contract, right?
That is correct.
Okay,
and it also is correct that it will not just be for a current contract or any contract, but in the future to determine the authority between the council and the mayor with regard to declaring local emergencies.
Yeah, but the law is what it is. I can't decide what the law is. I can't make the law. I can only decide what it is. And the law is that the mayor can do it or he can't. And I suspect in the final outcome of this litigation, we'll know the answer to that question. That's not what I'm asking you about. I'm trying to determine whether or not the mayor's interest and Richard's interest are different. And I can't hear you saying anything about how they're different. Richards wants exactly what you want. Richards wants me to declare. I'm not arguing from them. I'm just telling you my understanding of their argument, and then correct me if I'm wrong. But Richards seems to be arguing that the mayor does have authority, and the mayor did do it, and therefore they have a valid contract. And I don't know how that differs in interest. I don't know how that interest is any different from yours.
Richards is also talking about the RFP process under 31731. I believe that's the statute. I'm not sure if I don't have it in front of me, and that's not what this case is about. Our case is not about the RFP process. Our case is about what occurs during a local emergency. That differs, and it's correct that Richards would like the contract us to win. We are on the same page with regard to the contract that the mayor signed being valid. That we are on the same page, which is one of the reasons why it's not necessary for them to intervene in this action. That's one of the reasons why.
I get that. I'm with you on that, and I understand your argument. But with respect to what Richards has argued or has stated in their motion, is there something you? Again, I hear you making the argument that they are bringing up the RFP process, and that's not what you're here for. But have they brought up something in that respect or in any other respect that you disagree with, that you think they're wrong about?
That I think is wrong about? I think it will be a conflict between that the issue that we brought before the court is a conflict between the city council and the mayor. The issue they have is a conflict with the city as a whole, which is something that the city would need to defend. I'm not sure.
All right, you lost me there. I don't get that.
In their underlying complaint, they're asking for injunctive relief against the city as a whole, not the mayor in his official capacity, but the city as a whole.
You're losing me, Ms. A. You're going to have to get to Supreme Court to explain that one to me, because if the mayor wins, the city wins. Mayor loses, the city loses. I see no difference in the interest of the mayor and the city unless someone files a motion or a separate lawsuit or something asking the court to declare the mayor didn't have authority to do what he did. Mayor Lumumba did what he did. He either had authority to do it or he didn't. If he had authority to do it, there is no difference in his position and the city's position. He is the city. If he didn't have authority to do it and somebody's making that claim, then that's going to have to be decided.
It's my understanding that the city council is saying that the mayor did not have the authority to enter into the contract. So that's why there's this conflict, because the city council is also a representative of the city of Jackson. The city council represents the city of Jackson.
The city council is a different department of government, Ms. Ayers. The mayor's office in the city is the executive department, and the city council is the legislative department, and they serve different functions. But the law determined, as I understand it, that the mayor decides what contracts to sign, and the mayor decides what lawsuits to file.
And we agree.
Pardon me?
We agree that the mayor does make the determination, but the city council does not agree. They believe that they must approve everything, and that's the conflict that's the conflict we're seeking in our underlying complaint. That's the relief we're seeking, for it to be clear which roles they play in this matter.
I get that, and I appreciate that distinction, and I don't think you're wrong about that being an issue. Where I'm having trouble with your position is on the interests of the other parties. I can see that Richards has an interest in having the mayor prevail in this because they get a contract, and you agree with me on that, right?
Yes.
I can see where waste management and waste disposal doesn't agree with that. They believe that the city council should prevail. And to that extent, you're not representing their interests, and their interests are going to be decided by the outcome of this litigation. If the city council wins, they get a contract, and if they don't get a contract. Isn't that right?
I don't believe that is correct. I think the mayor has additional authority pursuant to the law with regard to any contract that the waste management could potentially be awarded. And also, waste management does not have a contract. It stands in the place of any vendor who could file an action in this case and move to intervene and tell this court that they have a right to intervene because they could potentially get a contract from the city council or the mayor.
But they didn't respond to the RFP, and Waste Management did.
Waste Management did, and other companies responded to the RFP as well.
Right.
But this is with regard to a local emergency when the city does not have to follow the procedures required under the RFP when selecting vendors to help support the city in its emergency efforts. So with that in mind, the person who gets the contract, an emergency contract to help the city under a local emergency does not or did not have to have a proposal submitted under the RFP process.
Okay. So bottom line is, with respect to Richard's petition to intervene, you do not think they should be allowed to intervene because their interests are protected by you. Is that correct?
I believe their interests will be, they don't have any interest that's specifically divergent, neither they don't, nor Waste Management. Their interests will both be addressed with the court's determination of the legal authority of the city council and the mayor. That's what I believe. Not that I'm pushing their position. I'm pushing the mayor's position. I am.
Well, let me ask you this. You're making it really hard for me, Ms. Ayers, but I understand you're pushing the mayor's position, but is the mayor's position he's entered a valid contract with Richards?
Separate, independent of this litigation? Yes, Your Honor. It is his position that he's entered into a valid contract.
Then what's the difference in the mayor's position and Richard's position? With
regard to the emergency contract, there's no difference.
Okay. And so, but you nevertheless do not agree to their intervention?
I don't believe it's necessary, Your Honor.
Okay. All right. And with respect to waste management and waste disposal, you don't...
I'm sorry, Your Honor.
You don't think they should be, even though their interests, as I said a minute ago, just to be sure you know where I am, my concern is that we are litigating an issue, the outcome of which determines whether or not they have any interest in pursuing their claim that they're entitled to the contract. They claim they are. If they lose, if you win, they for sure don't. They lose. They don't get a contract. If you lose, they at least have the argument that they've made with respect to Waste Management's right to have this contract. But nevertheless, you think they shouldn't be allowed to intervene?
No, they do not have a legally protectable interest in this proceeding, Your Honor.
All right. Counsel for Richards.
Yes.
I'm still having trouble understanding why your interests are not being adequately protected by Ms. Ayers and her position in this case.
Because in Ms. Ayers' pleading, she says that Richards has a conditional emergency contract.
All right, stop right there. Ms. Ayers, what is that all about?
The conditional contract is in their contract. It states there's specific language in there about, I do not have it in front of me. Excuse me, Your Honor.
Wait a minute. When this issue of conditional contract comes up, you're only referring to something that's in the contract and it means what it means. Is that right?
Yes, Your Honor.
And you're not trying to litigate that here?
No, Your Honor.
All right, is it Ms. Walker? No, not Ms. Walker. Who is it?
Green.
Ms. Green. I'm sorry. I apologize, Ms. Green. Your name's not up on the screen. Ms. Green, do you understand that issue, that we're not litigating the question of a conditional contract? Ms. Ayers is saying there's something in the contract that refers to it, and it says what it says, and how it would affect the contract. She's not taking a position one way or the other in this litigation. So how is your interest different?
My interest is different because if she would say in the contract, in her pleadings that it's a valid contract, the way the pleadings are, it's as if she's saying that the contract is not valid. Number two, Your Honor, is that everybody in the pleading is also including the RFP contract. The city council has specifically filed a motion for hearing an emergency relief based on RFP. Waste management.
Yeah, but they don't get that hearing and they don't win if Ms. Ayers wins. So that's not an issue. The city council and the RFP issue and the question of whether or not waste management gets a contract is determined, first of all, by whether or not Ms. Ayers prevails and whether or not she's correct that the mayor's contract's valid with Richards. And so what might be pursued by the city council is it has nothing to do, I don't think, with, I mean, what is it that you want? Here's a better question for you, Ms. Green. What is it you want to argue in this case that Ms. Ayers isn't going to argue?
I want to argue two things. First of all, if we're dealing with only the emergency contract, I would like for a specific statement from Ms. Ayers to say that the contract with Richards is valid. Number two, if the RFP process is going to be brought up, as it has been throughout the pleadings, then Richards still has an interest that Ms. Ayers has not touched.
Well, I think Ms. Ayers has said that her position is that the contract with Richards is a valid contract. Ms. Ayers, isn't that correct?
That's correct.
Yeah, and the RFP process is not going to come into play if the court determines that the Richards contract is a valid contract. And so what this litigation is not about the RFP process. It's about whether or not the mayor had the authority to enter into the contract, isn't it?
What you said.
Let me take a quick look here. Let's just look at it and see. The lawsuit that's before me asks for, I guess this is the best way to do it, Ms. Green. Can you hear me?
I'm sorry, no, I
said, can you hear me?
Yes, I can now.
All right. The Mayor Lumumba's complaint asks for three things. The first thing it asks for is that the city council has no authority to negotiate and or execute a contract for the collection of residential solid waste absent the existence of the exceptions in 21.8.19, Mississippi Code 21.8.19. Do you disagree with that? It's in the complaint. You should know by now.
No, I was about to say, no, I don't disagree with that.
All right, number two. The complaint asks, secondly, that the city council has no authority to amend the mayor's declaring a local emergency, and instead, after the mayor declares a local emergency, the city council is required to approve or disapprove the proclamation. You disagree with that?
I don't agree with that part.
Pardon?
I don't agree with that statement.
And number three, the mayor has the authority to find independent contractors, vendors who can provide necessary emergency services and present contract to the city of council for approval. Now, let me just say that I realize that that doesn't mention Richards, but Ms. Ayers has stated on the record that if she prevails, if the mayor prevails in that portion of the complaint, that Richards gets the contract. So do you disagree with that provision?
I disagree with that provision.
In what way?
I agree with the first two. I disagree with the third one because the statute does not require that contract to go to the city council for approval.
All right, now you've got my interest elevated a little bit, Ms. Ayers. What do you say? Ms. Walker says the contract doesn't have to go to the city council. You say it does in the complaint.
I believe it does have to go to the council for approval, but I believe that if any action that the mayor feels is the council, if the council were to disapprove a contract in this situation, that the mayor is allowed to veto that action.
But you don't say that in your complaint, though.
I say it in the steps.
You say
H, page 19, H, step 4, option 2.
All right. Ms. Green?
Yes. That's what I'm in disagreement.
What she is saying is that part of the complaint says that if the mayor vetoes the council's disapproval, in other words, she's saying that it's got to go to the council, but if the council disapproves it, the mayor can veto that. Do you disagree with that? I think never mind. I think I get your argument. You're saying that your argument is maybe so, maybe not, but whether the mayor does or doesn't have authority to veto, it shouldn't go to the council in the first place. Is that what you're saying?
Yes, Your Honor. And then I have to add a thing, that even if the mayor should veto the council, it does not help me, because with the AG opinions, then the mayor cannot veto an action unless it's an affirmative action.
But that's just on the merits. I mean, that's your argument on the merits. I mean, it seems to me that there is a substantial difference, Ms. Ayers, in your position and Ms. Walker's, because you think this thing's got to go to the city council and whatever happens, happens. And Ms. Green said it doesn't have to go to the city council at all. And I don't know the answer to that question, but that's a difference in legal position. Don't you agree?
It is.
Okay. All right, I'm going to go back to waste management and see if you've got any response to what we've covered so far.
I don't think I have much to add. I don't know that much of what was argued addresses what I raised earlier. I would note that the relief that we're asking for is broader than what the city council's asking for. So I would say for the court that they are not in a position to adequately protect our interest. And I think you sort of hit the nail on the head on the one issue that a contractual right or a right to have the RFP process followed is beyond an economic interest. And so I think you're on point with that. So I feel like we easily meet the test to intervene, and we should be allowed to do that.
Well, to be clear, it's more than the interest in having the RFP process to be followed. It is the interest in having the contract. The economic interest that flows from having the contract is different. Every lawsuit that's ever been filed where the plaintiff seeks money and someone seeks to intervene, there's going to be an economic interest, but the interest in the case may or may not be purely economic. And so I get that. Okay, and I should have prefaced that, Mr. Bryan, by saying you don't have to respond. You don't have to say anything else if you don't want to. I'm not requiring you to do that. I just wondered if you had something to add. Waste Disposal Council, do you have anything to add?
Yeah, I have nothing to add.
All right, Mr. Gibbs. And what about Richards? Still on mute.
Nothing further, Your Honor.
All right. I'm going to take this under advisement, and I'll issue an opinion within the next day on this intervention situation. Let me do this. First of all, let me just ask you if you. I don't know whether the intervention is going to have any effect on this or not, but I would like to know the position of the parties on whether I could just set this thing for determination on the briefs and have you all agree on the exhibits, and I could hold an evidentiary hearing in the event there's a disagreement on exhibits. But I just don't see the need to have a big trial if all we have is a legal dispute. It requires me to look at the statutes and the documents and make a determination of what the legal rights of the parties are. I don't see that we need a court reporter and to call witnesses and all the rest of that. You can just simply submit the documents by agreement unless some of you disagree that some of the documents are valid.
On behalf of the City Council of the City of Jackson, without objection and agreed to, Your Honor.
All right. Well, let me stop everybody. Let me hold on. Somebody's not on mute. I don't know who it is. I think it's you, Ms. Green. Yeah, there you go. And Mr. Brown, you aren't either. You need to mute yourself because you may say something you don't want us to hear. Let me ask all of you on behalf the council, on behalf of your respective parties, submit to me by tomorrow your client's position. I won't give you a day to think about this, but submit to me by tomorrow your client's position on whether or not we should proceed with a trial, an evidentiary trial in a court reporter, or whether I can simply address the issues raised based on the law and agreed exhibits and agreed facts. And let me add one thing. I do believe I have read a couple of references where it appears there might be a disagreement over whether at a particular point in time there was an emergency or there continued to be an emergency. I think I read that in a couple of places, and that might be a factual dispute. However, I don't know what anybody could add to the determination of that dispute other than the facts that are agreed. In other words, I know that the waste management contract expired at the end of March, or is going to expire at the end of March. I know the timeline, and I appreciate the one that was just submitted to me. And anybody else that wants to submit a timeline to me, I'd appreciate that. But I don't see anything that anybody disagrees with in terms of what happened and when. And so, to the extent there has to be a judicial determination of whether or there was an emergency at a particular point in time, I don't see the need for witnesses unless you do. And so consider that, talk to your clients, and get back to me tomorrow with your position as to whether or not I can have you submit agreed documents. And I've already got memoranda, but I'll allow you to submit anything you want in terms of additional argument, a case law. I appreciate it when you just email me PDFs of the cases that you argue, and you're welcome to highlight them to draw my attention to the portions that you're interested in. But I just believe I can decide this case based on the statutes that control the facts that are in agreement, and the documents that I have seen so far. Now there may be others that I haven't seen, but the two disputes that I'm concerned about you thinking about, taking a little time to think about them and make sure we're in agreement, are whether or not there continued to be or was at any particular point in time an emergency. I need to know your position on that. And then the other one is this issue, and I'm not quite sure I understand it, about whether the council did or did not include its determinations in the minutes of the city. I understand the city can only speak through its minutes, but I don't know what did and did not get filed or what is or is not reflected in the minutes, and I need to know if that is the kind of factual determination that's going to require witnesses. I just don't know. So y'all consider those issues and let me know your position by tomorrow. and then I'm going to spend tomorrow looking at the law and your arguments, and I would really like to get this thing decided before the end of March, so there's no real reason for us to extend beyond Waste Management's termination of its current contract before we know which way this thing's going to go. And it may not then, because you may appeal to the Supreme Court and they may end up having to decide this thing. I don't know. But I'm going to try to give you as much time as I can, because I know this is important. It's very important to the people of Jackson and to the whole state, really. And so let me just jump back. Waste Management, anything further from you?
No, sir.
And Waste Disposal, anything further from you?
Your Honor.
Richards?
Yes, Your Honor. I mean, the issue of no minutes is I think it's going to be very pivotal in here, because none of the actions that the city council contends that have taken are in any minutes whatsoever of the council. And Richards has expended, on this contract, expended tremendous money and time, and is ready to go on April 1.
All right, but Mr. Walker, and I don't disagree with what you're saying, but what I'd like you to consider is this. Either the council has minutes or they don't. They're not going to say we do and you say they don't. I don't believe they either have filed their minutes or they haven't. And if they haven't, that has whatever legal effect it has on this case. And if they have, it has whatever legal effect. Now, I could be wrong. Maybe y'all are going to disagree over whether the minutes have been filed. But it seems to me pretty easy to check and see. So I don't know why we need to call witnesses on something that y'all can look at and just tell me whether or not they've been filed. Mr. Walker, am I wrong there?
No.
Sir?
No, I think you're correct there, Jan.
Okay.
I think.
I just don't think I need to get a court report and have a trial over the question of whether the city filed its minutes, or the city council filed its minutes. You see what I mean? That's what I'm trying to avoid. I'm not going to stop. I'm not going to deprive anybody of their right to due process and to move forward if that's what it takes. But in the interest of getting this thing moved along and judicial economy and the cost to your clients and all the rest of it, if it's something I can just decide based on agreed facts, and I can make a determination of the legal effect of those agreed facts, and I don't see the reason to have a trial. So think about that, Mr. Walker, and if you think we need an evidentiary hearing on whether or not the city council filed its minutes, and I'll certainly have one for you, but give that some thought if you don't mind. Do you have anything else?
That's all at this particular time, John.
All right, and City of Jackson, here through City Council.
Nothing further, Judge.
All right, Mr. Martin. And so the City Council itself, counsel for the City Council.
Yes, sir. Independent special counsel for the City of Jackson City Council. Nothing, Judge. I'm in agreement with what you said.
Okay. All right. And just to be sure, anybody else got anything to add?
If I may, Your Honor.
Yes.
On behalf of the mayor, I think that we need to go ahead and disclose to the court, because there's been some discussion about the lack of minutes from the city council, which is required under the statute.
Yes.
And this afternoon, we have filed an emergency petition for writ of mandamus against the city council. So that probably is going to be factored into this particular litigation that has gone from circuit to chancery, and now we file something back in circuit because that's the proper place to file it. So
you filed a circuit action for mandamus, asking the court to force the city council to file its minutes.
Yes, because there have been no minutes, my understanding, since September of last year, and we would September of 2021, and we would need those minutes, and we've asked for specific relief. And we'll just have to see what happens
Are you saying there are no minutes, or you don't think you haven't been able to find any?
There are none that have been, there are none as far as I am aware. Yeah. So that's what we need to see. I believe that there have been several.
Where did you file this action, this mandamus?
In Circuit Court, Hines County Circuit Court.
Okay.
Yes. I believe there have been numerous requests made over the months, last several months, but there has been no response. So we would necessarily need those minutes. So, and perhaps when we report to the court as directed by tomorrow, we will have some additional information on how that's going to be handled there, and we would disclose that to the court at that time.
Very interesting. Okay. Well, I appreciate you letting me know that. I did not know that had happened, and that's and you're telling me that. Well, you are. You're saying that you agree there are no minutes from the meeting, and your mandamus seeks to have them filed.
What I said is, if there are any minutes that exist, I am unaware of them. So, and according to the mayor, he's requested them, or his people, and none have been produced. So.
Is it your position that the law requires the minutes to be filed to be legitimate, or that just simply they exist?
I think that there's a process that they have to be prepared and maybe transcribed, and I believe presented to the mayor for approval.
See, I've always thought, and this is just off the cuff, and I'm certainly not making a decision on anything here, but I always thought that the city speaks through when its actions are spread on the minutes, and the minutes are an official collection of those actions that are viewable by the public.
And I think that may be correct, Your Honor, and that is part of the problem, because I don't think that any of that exists. Yes.
I just don't want to get confused here. You're not saying that it's possible for the city to have official minutes that are not spread on its public minutes. You're just saying that somewhere the city may have a recordation or a collection of its actions, and you want those spread on the minutes. Is that what you're asking for?
Yes. Okay. I think that there may be minutes, but they are not official because they have not fully complied with the authority. Yeah.
All right.
Yes.
And you're representing the city?
I am the one who started this litigation that we're here today and filed on behalf of the mayor against the city council.
But I mean, you are the person that's filed this mandamus action in circuit court?
Yes, sir. That is correct. Along with Ms. Ayers.
Your Honor.
Yeah.
This, according to the statute, section 211533 and 211517, those minutes must be prescribed and also placed in the minute book with the city clerk.
That's what I thought. I don't think minutes are minutes unless they are, just because the actions of a public body are written down, they don't become minutes until they are published in the public book, in the minutes. That was my understanding. I don't know that that's true. I've never researched it, but that's my understanding. But okay, well, that's interesting, and it certainly will have some effect here. But once again, I don't see that there's a factual dispute. It's a legal dispute. The city council met. They have a transcript of what was discussed. They may or may not have some writing that purports to disclose the actions that they took, and that writing is or it isn't spread on the public minutes of the council. I don't think we'll disagree on any of those facts. The question would be, the only question would be the legal effect of that. So, do you agree with that, Ms. Green?
Yes, I do.
All right. Anybody else got anything? All right. Well, thank you all so much for your attendance and your courtesy here today. I'm going to do my best to get this thing decided by tomorrow. And what I mean by tomorrow is I'm going to wait till I receive everyone's submissions with respect to whether or not we can proceed, and whether or not you all have anything to add before I make a decision on the intervention part of this thing. And if you all agree that we can proceed without an evidentiary trial, then I'm going to give you a week. I'm going to give you 1 week from tomorrow to submit, to confer together, and I'm going to ask you to do it in good faith as professionals and officers of the court. I'm going to ask you to confer and make a determination of the documents that are not in dispute. Don't disagree with a document simply because it doesn't help your client. Only disagree with the document if you think it's not legitimate, if you think it's forged, or you think it's not a legitimate, if you think it's not authenticated with respect to the person who wants to present it. I'm asking you to do that so we don't get into a big discovery dispute. And y'all get together in good faith and within a week and provide me with the documents and your arguments to the extent you want to amplify what you've already submitted, and I will get this thing decided before the end of March, maybe even by next weekend. Tomorrow is Tuesday, so when I say take a week, I mean end of business Friday. Get it to me so I can look at this thing over the weekend. If any of you want an evidentiary hearing, let me know what it is you want an evidentiary hearing on, and explain it to me so I can go from there. And then I will take a look at what Ms. Perkins, you're going to send me a copy of the complaint for mandamus, and
yes, I'll send it now.
I really think, I know what's going to happen. What's going to happen is that thing's going to get filed, and all of the judges are going to recuse. It's going to go to the Supreme Court, and they're going to send it to me. Do any of you object? I guess I shouldn't put you on the spot. When you submit to me tomorrow, also let me know your position as to whether you think that I should decide that mandamus or someone else. And if you think I should, I'll contact Chief Justice Randolph and let him know the circumstances so we can not hold up this litigation. That's my only concern here, is to try to get this thing decided timely. And so I will contact him and try to speed up the process of determining who's going to decide that mandamus, because that could be a very big issue. It may not be a big issue at all in this litigation, but it might be very important. So let me know when you submit to me tomorrow what your position is on that. And all right, so that's City of Jackson City Council. That's everybody. Anybody got anything else before we sign off?
Your Honor, this is John Walker again. I just want to make sure where we are. What we're submitting tomorrow is whether or not we disagree about having a trial on the merits without witnesses, without an evidentiary hearing. Is that?
Well, it's actually whether we, if I can clarify, Mr. Walker, it's actually whether or not I can decide this thing without the necessity of a trial, that I can just decide it on the briefs and the documents that you submit and make a legal determination. A declaratory judgment's a little bit different from a jury trial in many instances, and there's no prohibition if the parties agree, and I'm asking if they agree, that you simply submit the evidence by agreement by tomorrow, that let me know that you agree to submit the evidence by agreement without the necessity of a trial and a court reporter and factual witnesses. And you can answer that by tomorrow and let me know.
Well, I guess the other question was, Yana, is in terms of whether or not the court is going to allow intervention of one or any of the parties, when will we have a decision on that? Or how that, what is,
Well, what I have
what
committed,
tomorrow?
yeah, what I've committed, Mr. Walker, is that I'm going to receive whatever you all file tomorrow, and I'm going to make a decision by midnight tomorrow night. I will make a decision and file it in MEC with respect to intervention. With respect to the merits, I'll take into account what you send me tomorrow, and assuming nobody disagrees and everybody believes we can proceed without the necessity of an evidentiary trial, then I'm going to give you to Friday to submit any additional argument on the merits of the claims in the complaint and the response to it. I'll give you to Friday to submit any additional law, any argument, and to confer and provide the documents that are in agreement, and submit those to me, and I'll try to decide the merits over next weekend. So I'm going to decide intervention by tomorrow night. I'm going to decide the merits by the end of next weekend, and all I need for y'all to do is to determine if I can decide the merits by next weekend by briefs and agreed documents, or if I need to get a trial date and a court reporter, which I'll try to do as quick as I can. So I need to know that answer to that question tomorrow. Is that okay, Mr. Moore? Is that suitable?
Yeah, that explains. I was just trying to get a clarification on that, Judge.
Okay, I apologize. I know it was a little muddy there, and just I don't want anybody to be caught off guard here. Anybody else? Ms. Ayers, you okay with how we're proceeding?
Yes, Your Honor, I understand everything.
Mr. Gibbs?
Yes, Your Honor, I understand.
Okay. All right, then. Then thank you again. Thank you all for your courtesy here today, and I will wait to receive your submissions tomorrow, and we'll get this thing decided. And if any of you wish to file anything in court, any kind of pleading in court, please copy me on my email address. And I'm sure you all have it, but if you don't, it's justicedickinson@gmail.com. So just give me a copy, shoot me a copy, so I'll have it, quicker than having to go through MEC to get it. All right, I'm going to sign off. Thank you all. Well, the court's adjourned.
Recording stop.